Medical Soup Podcast. I'm your host, John Toll, and with me today I have Danon, Nick, and Paul. I'm sure you're familiar with all those guys by now. We're going to talk a little bit about patents and intellectual property rights today. The article is from BBC. I'll post the link down below, or Paul will. Thanks, Paul. So the article is Are Patents Good for You? By a guy named Rory Sellin-Jones. And the current battle between a number of software developers and an American firm called LoadSys seems to show patents can have a chilling effect on entrepreneurs. The case has leaped into the headlines now, and by now it's actually 6 months old, but anyway, by now that the Angry Birds maker Rovio has been targeted by LoadSys, a company based in Texas which says it owns a number of patented technologies. What brought it to his attention was a conversation with a young British developer who was also facing a lawsuit. His contact, who does not want to be named, is a one-man band who has great success with an app for both the iPhone and Android platforms. But 10 days ago he received a bulky document through the post from LoadSys. It accused him of using, without permission, a patent relating to in-app purchasing, something introduced by Apple recently, and warned him that unless he paid a licensing fee to LoadSys he could end up in court. He had become the latest in a long list of developers, big and small, to be drawn into a legal battle with a firm conveniently based near the East Texas court, which has proved itself sympathetic to the rights of patent holders. I'm sure that has nothing to do with the money that it's made for the court. Now, software is harder to patent in Europe than in the United States, and it would appear unlikely that LoadSys would take this battle to the British courts. So, you might have thought the developer would have treated the letter as a cheeky attempt to extract money and throw it in the bin. But it left my contact worried and confused. I've got no experience in that area, and I didn't really understand what it was about, and I didn't want to go to the expense of hiring a patent lawyer. One answer would be simply to withdraw this app from the Apple's United States App Store, but that's where the majority of its customers are. He has contacted Apple and Google, who've both said they will be in touch. Apple has already intervened in the wider case, writing to LoadSys to say it's licensed the technology in question itself and to lay off its developers. I suppose I could just go pay a few $100s and hope it goes away, says the developer, but if I do that, then it could be seen as an easy target for others. So what exactly is LoadSys and what does it do? From its website, it seems its business consists of acquiring patents and launching lawsuits. There's no evidence that it actually makes anything. Read through one of its patents and you will be none the wiser as to what the invention involves and why it deserves the protection of the courts. But of course, I am not a patent lawyer. Experts tell me the landscape is shifting in patent law, with the American courts less friendly to this kind of tactic, while in Europe it has become slightly easier to patent computer-based innovations. I emailed the chief executive of LoadSys, Mark Small, to try to have a conversation about these matters, and he swiftly sent me a very polite reply. We have to respectfully decline. We have made the decision not to do press interviews and apply our resources to licensing discussions. But here's what I would have this is what I would like to have asked him. Is a system that appears to reward those who acquire patents and hire lawyers and punish those who simply try to make things really going to encourage innovation? My contact is certainly not doing much innovating right now. He's too busy worrying about the threat of an expensive lawsuit. Alright guys, who wants to go first? Go ahead, Paul.
Yeah. Well, of course, as far as intellectual property, I'm going to come out on the side of freedom, and essentially, intellectual property is nothing more than the government licensing a business or company to have a monopoly for a certain period of time, and monopolies really don't help matters at all. I mean, they make things more expensive. They make things. They stifle innovation. That's my big beef with the whole thing.
I'm curious how. I mean, I guess I'm a little surprised to hear you say that. Given that intellectual property is still property, and if it's not, then I'd be interested in how you see it as different. Why is that not subject to protection by the government?
Well, to start out with, most ideas, 99.9% of ideas are not original, and so therefore to claim property over something that you didn't even dream up seems a little weird to me. I mean, essentially, with a new product that's innovative, you're taking technology that's already pre-existing and adding to that.
But part of the motivation to do that is that it is your or your company's creation, and that they will profit from its not invention, given what you've said, but perhaps a new application of an old idea or something similar.
Or it could be an invention. It wouldn't really matter. But I mean, the point is that yes, absolutely, they should profit from it. But should they profit from it at the detriment of society? I mean, would it be okay with you if we patent, I don't know, the shirt you're wearing?
No, I certainly, I'm sure we'll get into this. There are a whole bunch of patents that are frivolous and are harmful, I think. But I guess I'm sort of approaching it from the basic concept of a patent, as far as whether to just eliminate the patent office altogether or whether there actually are patents that are useful and beneficial.
Hey Paul, let me get you to can I get you to repeat that last statement again that you said about beneficial for society again?
I'm not sure what statement you mean.
I know you don't need to repeat it exactly, but basically what I'm insinuating, and I think Nick's getting this, which is why he's getting excited, but you said something that sounded almost kind of socialist to me. Something about the betterment of society. Go ahead, Nick.
Not socialist at all.
Hold on, Paul. Go ahead, Nick.
I don't know. This is funny because I feel like I'm in Bizarro World listening to these guys right now. But let's on its face, if you're a true free market advocate, then you couldn't ever be an advocate for patents. Because what a free market person would tell you is that the advantage should go to who could ever produce whatever the product is cheapest. And they should have the right to move in the market. What a patent does is that it introduces a regulation into the marketplace. And by the way, I'm not arguing against patents, but I am saying it is a regulation, and it's a regulation that corporates tend to like. And so when I hear Paul talk about the society is better off, I really think what he's trying to say is the market.
See, I disagree that it's a regulation, because regulations are the government imposing its own will onto corporations, whereas patents are the force of government to protect private property. So it's no more a regulation than the government protecting my home against break-ins would be a regulation.
My argument is, why then does intellectual property have a time value to it? Why are patents only for 17 years? If
That's perfect.
But what it comes down to is the communities are best served by patents that expire, because then there's competition introduced into the production of a product.
See, this makes me think of the drug companies and how the prices drop for major drugs as soon as the patent expires, because then you get all kinds of generic versions and such, which is great for the end user. However, if the developing company was not able to make back its expenses before the patent expired, then I think we would see a whole lot less innovation in that field. If suddenly it was fairly open to other people to just come in, know the formula, and run with it.
I think you're being awfully pessimistic about capitalism. I mean, it's true. I mean, honestly.
That argument's a lot to others, so.
Yes, Nick, you are in Bizarro World, but go ahead and continue, Paul.
I mean, honestly, if there's a buck to make, capitalism will make it. I mean, the free market, actually I shouldn't really say capitalism, because Marx coined that term, and that's really, I hate taking from Marx
I didn't know that.
Yeah, actually.
Yeah.
But in any case, the free market system will always find a way to make a buck. And, you know, if it means really, really cheap drugs, they'll do it. They'll find a way to do it. I guarantee.
Yeah, it's a little vague though. I wish we had something a little more specific. I mean, you look at complex electronics or I hate software because that's a big issue with respect to patents. But I have to think a lot of other things would take a good deal of reverse engineering to figure out how the product is made and to be able to duplicate it adequately. But with drugs, all that stuff, you can say this is another government regulation, but it's mandated that, as far as I know, the formula and the chemical compounds and all that are publicly available, which I can't really fault. I mean, can say the FDA oversteps its bounds if it wasn't issuing drugs like that have significant effects. I mean, I can appreciate that. So that, I mean, that's just publishing the schematics and duplicate the product. So I wish we had something a little less vague than just, oh, the market will find a way. Not that I disagree with you on that.
I'm not sure that there's anything that's not going to be relatively vague, because what we're dealing with here is not what's seen, but what's not seen. Because we're living in a society that has intellectual property, and we see this society. We don't see the society without intellectual property.
Well, we have the article that we just started talking about, started the whole show with, as a very specific example. And yeah, again, it's software. So Dana, you're right. This is a little bit different situation than, you know, like a physical invention or something. But that's an example of somebody kind of getting hosed out of their own ideas because some element of their idea was patented, like a general concept. I mean, these are things that are, in my opinion, and I don't normally share my opinion, but these things are vague enough that it's almost criminal that something like that is patented. But it's difficult because how do you decide what's patentable and what's not? What's an idea that is specific enough to patent and what is not? And
that's why I haven't come to a firm conclusion on this issue, because there are definitely some software or even hardware things that it makes it almost impossible to really develop any kind of embedded device or software interface without getting sued.
Yeah, and that's the argument against it. Here's an argument
Well,
for
I think
it. Go ahead.
One solution. Sorry. I would say, well, one solution is simply not to make patents such long-lived. I mean, you can make a patent much shorter than the 17 years or 12 years or whatever it is for certain types of technologies. If you start having 3 or 4 or 5 year patents, then the life of those things doesn't exist, and you can continue your own development of products on top of that without having to worry about somebody holding a long-lived patent on a component of your idea.
But can't we stop pretending that somebody didn't create a speaker in the past, and now this little baffle that's behind the speaker is special because it's my baffle that I created? Can't we just stop pretending that some of these things are new? Because
we can, but I will. Yeah, but see, this is where I'll say, okay, I've made the whole point about a patent's really a regulation. As you guys know, I'm pro-regulation, so I'll come down on the side that we do need patents. I mean, it does spark innovation because people have a protection of their idea, and so while I've always maintained that having a smart set of regulations within the market is what's best for the market. I don't believe the current system, as it's put together, is delivering what we need. I think patents are way too long, and to Paul's point, it seems to me that just about any little idea can be patented, even though if there might not be intrinsic value in and of itself. It would have to be coupled with something else to really truly have value.
So Paul, Go ahead.
Do you really believe, honestly, Nick, that patents, intellectual property, copyrights, do you really believe that that actually does any good? I mean,
Well,
seriously.
yeah, I would say copyrights are probably a little bit different than patents, right? Because if you're writing a story, for example, I'm sure J.K. Rowling really likes the fact that her Harry Potter stories are copyrighted, and she should benefit from those. So I think copyrights are a little bit different. But I do believe that patents do provide, to use Danon's example around pharmaceuticals. I think it does provide somewhat of an opportunity for them to invest in research. Now, I want to be really careful because I don't want to make the argument that there's a connection between research costs and the price of our drugs, because there isn't. The price of a drug is determined by supply and demand, and when you have a patent in place, that's going to reduce the supply and drive up the price. But the ability for these drugs to be profitable, especially early on, does allow for research and development.
Well, let me tell you why I disagree with you.
Okay. You go right ahead. Wouldn't be the first time.
Probably not.
Won't be the last.
Would it surprise you to know that the clothing industry has no patents, no copyrights, nothing? Would that surprise you at all?
Would it surprise me? I haven't put a lot of thought into it, but no, it wouldn't surprise me.
Clothes have existed, though, since long before patent office or modern society.
They have trademark. That's all they've got. Would it also surprise you to know that the clothing industry has a larger share of the market than any other IP-able industry that exists?
I don't understand that comment.
Little. Yeah, elaborate.
Pick something that you can copyright or patent.
I mean, like generically, like automobiles.
Automobiles, that's a good one. They have the clothing industry is larger than the automobile industry.
In terms of annual profit, or?
In terms of
Annual revenues?
Exactly.
Well, yeah, but people need clothes. They don't need cars.
And that was my point. The clothes have been around since there was somebody to invent them.
Absolutely. People need clothes. But you know how long clothes last? They last for quite a while. And you know how cheap clothes are these days? They're pretty cheap.
It depends.
And how many pairs
where
of
you go.
pants do you have? How many shirts do you have? Do you need all those?
I like where you're going.
Well, my point is, people buy clothes not out of necessity. People buy clothes to be fashionable. People buy clothes, to have lots of clothes, whatever.
Promote the brand.
But the point is, I mean, clothes, yeah, while they are a necessity, at least in this society, they are not used as a necessity in most cases. I mean, there are a lot of people that are buying clothes for strictly fashion purposes. I mean, there are a lot of companies that exist that can't patent their products, that they can't copyright their products, but they still exist and they still make a whole lot of money because they're
Preaching
making
the choir, I get that. I understand that. It doesn't necessarily correlate to all industries, but I get it. I think that you make a valid point, but I also think that there is some validity to having the regulation around just intellectual property. I mean, I think that it does drive some innovation. I think especially in technical or research-heavy industries, it does provide some support to the research and development arm.
Okay.
And I don't... Go ahead.
I
Sorry.
was
Do
gonna
we
say-
have a break or something?
Yeah, I think we're getting up near the end here, and I know, Paul, you've got a retort lined up, but I think you've made your point clear. I'm going to end with just a little scenario for everybody to think about, and obviously we know how you guys are going to answer this, so we don't even need to get your responses, more for the audience. So let's say that Danon has a new toilet that he wants to invent that has a special kind of flushing device that he's going to sell to California because it's going to use a tenth the water. All right.
I was going to make that point. Toilets really haven't been innovated in a while.
See, so there's the
They're
deal.
overdue.
But the idea is, without patents, if he brings this up to a company, the company has every right to take that idea and just go do it without him. With a patent, he has some sort of protection. Now, whether that's warranted or not, and whether or not the company's best interest is not to do that to him, that's the question, and that's something that you might want to discuss, and maybe something we can discuss at a future time. But that's an example of a kind of a small fry situation. No offense, Danon, but where you're going to actually want to protect the property that you haven't even really done anything with yet. It's a concept, and it's to protect you from someone stealing your rights, even the people you might be interested in going to. But again, I know that Paul has a real answer for this, but we're gonna save that for another one. All right, Paul. All right, guys. I'm sure it'll come up again. Thanks again, guys, for your time, and we're gonna sign off.
Killing
So, good night.
Thanks.
Right.